Well, knowing when to settle a case or when you should go to trial can be a tough decision, but there are some signs that you can really point you in the right direction. Colorado's best attorney, Phil Harding, is here to help us figure out that direction, which way we should go. That would be tough. It's like, do you settle? Do you go to trial? I mean, what generally happens?
Well, hey, I've got to tell you, you know what? I'm going to talk today about civil cases and not criminal cases.
Civil ones, okay.
Yeah, just civil ones, and kind of go over that. And a little bit that we're going to talk about is we're going to go into my analysis as to when cases go to trial, when they don't go to trial, and what are the key things. And we're jumping ahead to the graphic, so let's do this. Actually, we're not ready for this graphic yet.
This is the win one.
Yeah, that's the win, but you know what? We can talk about that if you want, or
we can look at the numbers, because you said, really, this kind of surprised me, because I thought, people kind of getting that, like, I'm going to go to trial, I'm taking this to trial, right?
Yeah.
But you were saying a lot of cases settle.
A vast majority do, and even up until the filing of a lawsuit, more than 90% of them settle.
90% settle.
Yeah, and so let's talk about, I want to talk about the who, what, when, where, and why of settlement versus going to trial. And so the first thing is when, and so let's go back to this graphic and let's talk a little bit about this. And first of all, you need to settle before the statute of limitations runs. It always has to be in your mind when the statute of limitations. And this first thing that you see, it's called GIA, stands for the Governmental Immunity Act. Now, you don't have to file a suit before then, but if the government contributed to your injury in any way whatsoever, you have to give them notice. It's called GIA, Governmental Immunity Act. Like if you slip and fall on a sidewalk, or RTD, you're injured on RTD or something like that.
Governmental immunity.
Governmental Immunity Act, that's right. The next thing is kind of these statute of limitations. First of all, if it's a breach of contract, generally, and again, this is Colorado law, but generally it's a 3-year statute of limitations. Auto accidents, 3-year statute of limitations. Slip and fall. 2 years. That's a 2-year statute of limitation. And then also, don't settle your case until after you know all of your damages.
Okay, well that's good stuff. So, when you're talking about these cases, everyone thinks, okay, I know that I've got everything I need to win this. But you call that the theory, right? The theory of the case?
The theory of the case. Now let's talk about what you need to settle your case. And so first of all, you need to have, like you said, the theory of the case, and that's why you're right. The next thing is you need to know all of your damages. In other words, when you're done treating, first of all, you need to know your economic losses, which are your past, present, and future medical bills. Your medical bills also you need to show to the other side, but only the billed amount, not the paid amount.
Yeah, you've told us that many times.
That's right. So you cover up kind of a section with the lower amounts, only the billed amount. You need to show your medical records, but only the things that are related to the accident. So if your medical records talk about diabetes, something like that, you can redact that. You can cover up.
If that has nothing to do with your injury or something.
That has nothing to do with it, right. Cover that up. Next, you need to know your risk. And I want to talk about this. Let's talk about knowing your risk. To fully appreciate your risk, you need to know the law and who's on the other side. This sounds easy and basic, but many people miss the point. Your best way to settle a case if the other side is well educated on the law and has been through this process before. Look, I love it when I'm dealing with a sophisticated attorney on the other side or a big name insurance company. If so, they know, and I know, that trials are only used as a last resort when someone's not being reasonable. Large companies and insurance companies go through a risk analysis all the time, and in doing so, sometimes they know if they're against an attorney that doesn't have much experience, or they know that it's in their best interest with someone who doesn't have much experience to drag it out, make them sweat it out before trial, or even go to trial and outshine them in court with a better attorney.
Wow. So when it comes to the attorney, I mean, how do people, find the right attorney for them?
Yeah. Well, we've gone over that before, and you can always go to KWGN and look this up. But when you are looking for the right attorney, first of all, look and make sure that this person practices in your area and has experience. Most importantly, I want you to find someone that you can communicate with directly. For example, if you're dealing with an attorney and you only talk to their administrator or paralegal and you never talk to them, that guy has too many cases. So make sure you're dealing directly with the attorney. Now, we're going to talk real quick about the Colorado Rules of Evidence. Next week, we're going to go over a lot more, but it's really important. The first one that we want to talk about is Rule 408, which is settlement negotiations. And essentially what this says is evidence of the following is not admissible in front of a court of law, which is sub 1, valuable consideration and compromise in the claim. That means if someone offers money, or number 2, conduct or statements made during these compromise negotiations. Let's talk a little bit about this and kind of go into that. The reason why courts don't want you or don't allow you to tell, well, you know what, let's say you're in trial and you say, wait, you offered me $10,000 before court to
Yeah,
trial that.
I think I would want to say that in court. Why can't you?
You
say
can't
that?
do that because of this rule, 408. And what it says is it really wants people to get together and try to knock out their own settlement. Because if you knock out your own settlement, you're going to be so much happier than a court, a judge, or a jury shoving down your throat what one person may ask for and not the other. Also, they want to clear up their dockets. So when two people get together and try to knock out a settlement, I got to tell you, and you're going to think I'm crazy, the best settlement is where both parties walk away feeling like they got the raw end of the deal.
That's the best settlement, when
That's the-
everyone's like, oh,
Yeah, because
Man, I'm not
someone
happy.
took less, someone
Okay.
gave more than they should. You know, I know that there are more questions on this, and we want to go into a little bit more.
yeah, because it can be
it's
confusing.
important, yeah.
A lot of information, but the great thing is they can get a free consultation with you. Come in, sit down, go over all the pros and cons. So if you have any questions for Phil, just go to our website, kwgn.com, click on his photo, and you can send in your questions directly to him. He does take the time to answer them all personally and confidentially. And to reach Harding & Associates directly, here's his number, 303-762-9500. You can get a free consultation anytime. You can also check out his website, hlaw.org. Well, coming up on Colorado's Best, our King Soopers dietitian is going to show us how to eat our way to better hydration.
And we're live outside doing a little surf set. Oh, you don't need the ocean for this workout. Kim, show them the fancy stuff.